Tell you about the High Court sitting in Pretoria. It has heard submissions that the alleged confession audio recording of accused number 2 in the Senzo Meyiwa murder trial should be admitted as evidence and played before the court. Prosecutor Advocate George Baloyi believes this will assist the court. However, the defense fiercely opposes this. We're now joined by Melusi Xulu. He's a legal analyst to help us understand some of the legalities. Thank you very much, sir, for your time this afternoon. Perhaps let's revisit some of the moments as we heard them in court, in particular the argument that is being made by the defense.
Having regards that this is evidence which is still being contested at this stage in a trial within a trial, which we all know that the findings thereof and the evidence subsequently thereof, unless there is agreement between the parties, has to be compartmentalized on its own. Only maybe you could argue that the finding by this court to the contrary, I don't want to presume, to the contrary, may come to a point where that evidence is not related further in the trial itself, because these are two exigencies.
Yes.
Mr. Zulu says there is need for an expert. We heard him yesterday.
Yes.
When I said...
Yes, he mentioned that.
Yeah. At this stage, is it possible to appoint an expert? But if the exigency arises, or the need arises?
But we submit that there's no need, as we mentioned, that all that needs to happen is that the hard drive is retrieved from the laptop, a mirror image is then made and is then made available to court. We don't need an expert.
And at this stage, as I understand it, all the parties listened to except the court, yes, listened to the audio recording of that tape. Is that not so?
Yes, indeed. Over a period of 2 days. The accused have also been afforded the opportunity.
They also listened?
Yes.
So consequently, if there is a foreign voice in that tape, the defense still has a chance to attack the authenticity of that voice, which they allege is perhaps foreign.
Indeed, my lord, and they can put their version to Mrs. Grenier to comment, and all the parties, including the court, will then have the benefit of watching the recording and then making own observations regarding that aspect.
So is that your final submission, that this court cannot rule on this application without listening to the tape?
Indeed, my lord.
I suggested that yesterday and I was told cuckoo.
Yes.
Melusi Xulu, has the state persuaded the court or managed to persuade the court through their argument that indeed this audio recording should be admissible?
Good afternoon to the viewers at home. I think he had a well-prepared head of argument with a number of relevant case laws as to why it should be admitted. But obviously the defense is still going to argue, because Advocate Zulu has also raised certain points and the other advocates will come in. Last time I checked, it was Advocate Miss. I think also the point is, though, that I find very interesting. The recording was made, but the accused was not aware that it's being recorded. And I think those rights that are there in Section 35 in the Constitution, they should have also extended to the recording. I think that is the argument of Advocate Zulu, that you have the right to remain silent, and you must be aware that whatever evidence that you give to the magistrate, whether by confession, that particular evidence will be used against you. So he probably could have been aware that the confession which is written will be used against him, but he was not aware of the recording. So I think it's an issue of the awareness of the second part of the confession or evidence, which is the same as the written one, but it's also the issue of were his constitutional rights also explained to him in relation to the recording. Whether it's original, authentic, is also another issue, but I think the constitutional issue should be the one that's at the forefront of this debate.
Okay, in fact, let's revisit that moment, the argument by Advocate Mngomezulu on behalf of accused number 1 and 2.
This court is seized with an inquiry to make as to the admissibility of, firstly, of a statement that is alleged to have been made by accused number 2, which the defense is objecting to it and has raised the reasons for its objections, among other things, duress, which is coupled with non-compliance with free and voluntary, and it was not made in his sound and sober senses.
Okay, I'm sorry to interfere. I'm sorry to interfere. In your view, can this court, because the court is presently, as you say, involved in an inquiry regarding the issue whether the statement or the impugned statement or confession is alleged by the defense not to have been made freely and voluntarily, etc., right?
That's correct.
Now, this court, can it arrive at a decision concerning the inquiry which it is conducting without objectively viewing the photo, video, tape? I know your submission is that this court shouldn't view it.
That's correct.
But
that's the reason.
But then I'm asking whether this court can make a decision regarding evidence which is allegedly encompassed in that audio video without this court having viewed it.
It is indeed so, my lord.
Melusi Xulu, has the defense managed to persuade the court in terms of their arguments?
I think that will be clear when the judge ultimately decides. But what I observed was when Advocate Baloyi was presenting his arguments, he presented them, and he was not asked questions, and maybe for a lack of a better word, he was not disturbed whilst he was presenting. And I feel that the judge had more questions to ask to the defense than he had to the prosecution whilst the defense was still, making their arguments. And remember that more importantly, it's Advocate Mngomezulu who was representing accused number 2. So he has to really, make sure that his points are heard. And I don't know what that court will say about his representation on the right to, remain silent and self-incrimination, in particular to the recordings, because yes, for the confession, which is written down, it's clear that those rights were explained, but whether the rights to not to self-incriminate himself were explained in particular to the recording, I don't know how the judge would differentiate the two, because for me, I think as much as the recording and the confession is the same thing, but he was not told about the recording. And for me, this is the, crux of the issue, that he should have been aware at least that it's also being recorded.
Okay. Thank you very much for your time this afternoon. Melusi Xulu is a legal analyst.